so you're good. Start.
Okay. So, good morning, everyone. Thank you for inviting me to speak. My name is Ben Yeroushalmi. I am an elder abuse attorney, and I'm here to talk to you a little bit about what I do. So, first of all, I want to thank you and everybody who's going to be watching the video for going into this field. I think it's a very important thing to do, and I think it's wonderful that there is a gerontology program, and there are people who are dedicated to studying this field and helping improve access to care and quality of care to elderly adults. I think it's a very important thing, so my appreciation to all of you for pursuing this type of career. What we do is centered mostly around physical abuse in terms of neglect. There is an aspect of elder abuse that's financial. We don't do that at our firm, so probably there are people who are much more keen on that issue and more of an expert, so I'm going to stick to what I do. Physical elder abuse, and there's a statute codified under the Welfare and Institutions Code in California that defines what elder abuse is and provides an incentive for attorneys to take on the cause of the elderly who are neglected. But it's a very high standard to meet. In order to prove elder abuse, you have to prove your case with clear and convincing evidence, which is akin, it's the highest burden of proof in civil law. So for example, in an ordinary negligence case, you have to prove your case with the preponderance of evidence. So if you just show more likely than not, basically, that someone committed negligence and someone was harmed by it, you can prevail. In an elder abuse action, you have to prove with clear and convincing evidence that the person had goods and services withheld from them and that it caused their injuries. And it's obviously doable, but it's a much tougher standard. The statute defines elder abuse and the concept of neglect as some of the following. For example, failure to prevent dehydration, failure to prevent malnutrition, failure to prevent infections, failure to prevent bed sores. So these are some of the things that people, when they're elderly, are more susceptible to those types of injuries, especially people who are suffering from dementia or any other cognitive impairment. And by the way, a lot of the people we represent aren't always necessarily over the age of 65, because the elder abuse statute also applies to people who have disabilities. For example, there's some tragic situations where a very young person suffers either an accident or a stroke and is left paralyzed and dependent, and so they need a skilled nursing setting so that they can be taken care of and have their daily needs met. So some of the signs of elder abuse or of neglect are, again, dehydration, significant weight loss or nutrition issues, skin integrity issues. Some of the worst injuries we see are bed sores, when people are not turned and repositioned often enough, and they develop these horrific wounds on their bodies, which become gateways to infections, and they're very painful, and it's a whole other topic. Obviously, there's hygiene issues. A lot of the people we represent, unfortunately, are incontinent, and they need somebody to tend to their needs in that respect, and that puts them at a greater risk for developing bed sores as well. So, one of the things we'll talk about is if there's not enough people there to change them on time, then it's not just a violation of their dignity rights, but it leads to chemical reactions with their skin, which leads to further skin breakdowns and leads to further deterioration of their skin and development of bed sores. There's also falls, and people fall at home as well, and falls are one of the leading causes of injuries and unfortunately demise of the elderly. But in the skilled nursing context, or even in a hospital or an assisted living context, falls can be preventable. So it becomes, in a sense, neglect when the proper assessments are not done and the proper interventions are not done to make sure that you both prevent the likelihood of a fall and take steps to mitigate the injury that could be caused from a fall. When those things don't happen and the person is a high fall risk, that's a form of neglect. there's also infections, and unfortunately one of the things that are very common, but it seems to have waned a bit, is the over-reliance on chemical restraints. Giving people psychotropic drugs for the convenience of the staff, and not necessarily because it's beneficial to the patient. So, at least in my opinion, and I know this is shared by many people in the plaintiff's bar and people who are active in elder abuse litigation, the common denominator to these types of injuries, which are preventable, and this type of dignity violations, are understaffing. When you don't have enough staff to tend to the needs of everyone in the facility, and you don't have enough quality staff. So staffing is both, the adequacy of staffing is not just in numbers, but it's also in the education levels and experience of the nurses who are providing the care. So, a lot of times, well, first of all, in California there is a statute that requires a minimum nursing hour per patient day ratio of nurses to staff. So it's 3.2 nursing hours per patient day. So if you have 100 patients, in your census for a particular day, you have to clock in at a minimum 320 hours of skilled nursing work. First of all, that's wholly deficient in and of itself, and the statute itself says that the 3.2 is just the minimum, but there's another statute that says you have to provide adequate staffing to meet the needs of all residents. So adequate staffing to meet the needs of all residents is based on the overall acuity of the overall resident population. And so a lot of ways where that's sort of skimmed is, first of all, especially the facilities that are part of larger chains, they will get directions from the corporate to basically be at the minimum staffing because it cuts into profits if they go above it. And unfortunately, it's not just the fact that they do minimal staffing, but they go very slim on RNs, because you need more RNs, because only RNs are supposed to be assessing patients, but a lot of times they leave it to LVNs to do it, and they don't have enough RNs in the building, or they're not very experienced, and so a lot of things fall by the wayside. A lot of assessments that are supposed to be done are not done. So staffing is the sort of a common denominator to a lot of these things, because when you don't have enough staff, you don't have enough people to turn and reposition, you don't have enough people to pass snacks and fluids, you don't have enough staff to assess and to see what the condition of the patient is, how are they coming along. You don't have enough staff to assist them with feeding. A lot of times, unfortunately, one of the things we see happen a lot is, staff will come in there, they'll put the tray in front of the patient who cannot feed themselves, and then 10 minutes later, 15 minutes later, they come and take it off and they say ate 100%. And if you don't believe me, I have a lot of times where people have already been discharged from the facility and are in a hospital, and they're still eating 100% of their food, and they're having 2 bowel movements, and they've been turned in reposition. So there's a lot of false charting, or what they call charting parties. Now, in a sense, it's a dishonest thing to do, and I'm not, here to make excuses for anyone, but I think the focus is on where's the pressure coming from for something like this to happen? And it always comes from the top, because the nurses, for the most part, everyone I've ever dealt with, and even deposing nurses, or even when things have gone wrong, they go into the profession because they want to care for other people. It's not like, they're not in it for the profit. And so it's not really on them a lot of times when things like this happen. It's because they have too many people to care for and too little time. And so what happens is they become over-reliant sometimes on psychotropic drugs. They don't spend enough time feeding. They don't spend enough time communicating with physicians about what's going on with the patient so they can get the proper orders and the orders can be carried out correctly. So those are some of the issues. How do you prevent elder abuse in a nursing home context or a care setting context? So first and foremost, it has to happen from the top. There has to be sufficient staff and sufficiently trained staff and sufficiently experienced staff. So you need better leaders, more experienced RNs who have more discretion to actually run the show. And you cannot be putting too much pressure and too many patients assigned to each CNA to just make more money. It's understandable, obviously this is America, it's a capitalist economy, God bless them, we like free enterprise, we want people to make money. The issue is when especially larger chains and facility owners will place profits over people and will not provide the number of staff they need to actually take care of everyone. And so it always starts with staffing, and it continues with the training of the staff and making sure that they know how important it is to turn and reposition. They know how to do a correct assessment. They know how to assess a change in condition. They know how to communicate effectively with their superiors about what's going on with their patients, how important it is to pass fluids, how important it is to change a diaper on time. Then there's regular assessments, which again you have to have enough staff in order to do the assessment. So one example is, someone would come in, they're at a high risk for developing bed sores. Not only are they not being turned and repositioned regularly, but even according to the facility's own policy, their skin has to be assessed daily. But 2 weeks, 3 weeks, 4 weeks go by, nobody's assessing their skin. By the time someone catches it, it's already a stage 3 bed sore. And it's an uphill battle at that point to try to minimize the damage. Same thing with avoiding someone from becoming severely malnourished or dehydrated. If the proper assessments are not being done, you don't know how high their risk for dehydration is, and you can't tailor a specific care plan to that person. So timely assessments are key in the prevention of elder abuse. It really also has to do with effective communication between staff, because a lot of staff only work 3 or 4 times a week. Some are part-time. And the best way of communication in an environment like that is proper charting. So if people actually chart when they're giving the care and they chart correctly, and people can come in at the next shift and read what's going on with the patient, that's a form of communication. But again, some of the things we see sometimes, people who are at very high risk for multiple injuries, they have been charted on for maybe 19 days or 20 days or a whole month. Or even a week goes by, and for a lot of people that's too much. I think that from my perspective, all staff, and it goes from the top to the social worker to the administrator in a nursing home or director of nursing down to a CNA, have to be advocates for the patients. They have to be looking out for the best interests of the patients, and if they see something is wrong, they are by law a mandated reporter. The problem is obviously a lot of people are afraid of losing their jobs, so a lot of people are afraid to speak out. But within the nursing home environment, it's very important for everybody, all staff, to feel as if they are an advocate for the patient and to speak out when they see there's not enough staff around, there's not enough training, people don't have clear guidelines on what needs to be done, or they don't have the resources to do everything that they need to do. So what is the motive for elder abuse? And if you can prove with clear and convincing evidence that someone has been recklessly neglected, and the commission of the neglect was known at the top and it was approved. It's called ratification. If it's approved by a higher up, a managing agent in the company. And if that's done maliciously, then potentially the facility can be hit with punitive damages when the abuse results or neglect results in significant injury. So when you hear the word malice, it sounds pretty strong, I would say. And so a lot of people will say, well, how can it be? Do people really want an elderly or disabled person to suffer or to see their demise because they're not being cared for? So, as I always say, the malice doesn't have to be that a specific person wants someone specifically to be injured or to be hurt. It's that they know that if they don't take steps X, Y, and Z, if they don't provide the resources that are necessary to prevent the deterioration of this person's health, it is going to lead to their demise. It is going to lead to them getting injured. And they see it happening, and they are cited for it by the Department of Public Health as because it happened in the past, and they promise not to do it again, and they continue to do it. That's malicious because they understand the consequence of their conduct, even though it's not a direct intention of theirs to hurt people. They understand that it's a direct consequence, and they continue to engage in that action. How the motivations actually work, and this is something I wanted to talk to you guys about how do you fix the problem from a policy perspective. Essentially, the way it works is that every facility has an incentive to take on as many Medicare patients as possible. And Medicare patients, or especially higher acuity patients, lead to higher reimbursement by government or insurance. And people with higher needs obviously have higher needs. They, not only is the facility getting a higher reimbursement, but they have to actually be providing a higher level of care. When people with higher needs come into the facility, they increase the overall acuity needs of the overall population. And so it puts a greater burden on the same staff who now has to deal with more people with higher acuity. So that leads to sort of a motivation on the part of the facility to stack the facility or fill their census with as many high acuity patients as they can, because it leads to higher reimbursement. And at the same time, to decrease their staffing, because their highest cost is their labor cost. And that leads to the types of injuries that we see all the time that constitute elder abuse and neglect.
I have a question. So in that case, they need more skilled nurses, don't they?
Absolutely.
Yeah. Do they?
Well, this is one of the things we talked about, is that the quality of staffing isn't just the numbers, but also whether you have sufficient number of RNs or LPNs who have the training and experience necessary to properly lead a team, to properly assess, and to properly be an advocate for the patients. So another motivation is that a lot of these facilities, a lot of their services are contracted out to related parties. So for example, the same facility that owns the nursing home and manages it will also own the physical therapy company that's supposed to provide physical therapy. But a lot of times what happens is people come in and they're supposed to receive physical therapy, and it's supposed to be a short rehab stay, but they don't get all of the physical therapy that they need, and they become a long-term patient, which means that for long-term, the facility can continue to provide or to receive the reimbursement, whether it's from Medicare or Medi-Cal, on a daily basis, because that patient continues to be there. Whereas a lot of times, if they actually get the rehab care that they need right away, they don't need to continue to stay in the facility. A lot of times a facility will take on a patient who needs significant rehab, but that rehab runs out. For example, they may be only entitled to a certain amount of physical therapy through Medicare, or if they're only on Medi-Cal, they can't afford it. So their days run out, and they're not entitled to it anymore. The facility knows that, but they continue to keep them, and they understand that if they're going to keep the patient, they're going to have to provide the physical therapy themselves. But they also own the physical therapy company, and they're not getting reimbursed for it by Medicare. So what they do is they just continue to hold the patient, and they'll just say, this patient does not thrive anymore, does not benefit from physical therapy, so we don't have to give it to them. When they don't get the physical therapy, they become more bedbound, they become more lethargic, more depressed, and more prone to the types of injuries that happen too often. Physical therapists have a big role to play in the context of preventing abuse and neglect. And for a lot of times they are independent, but a lot of times they're not. And so what happens is they have to balance that sort of conflicting interest between what's in the best interest of the patient versus what is it that the facility is directing them to do or wanting them to do from a cost perspective. The person at the top in a nursing home is called the administrator. They're in the top of the chain of command, and the next in line is the director of nursing. But a lot of times, most of the time, the administrator is not really the highest person in the chain of command. There's usually someone from the corporate office. If it's a larger chain, it's usually like a regional vice president who the administrator reports to. And so the administrator is in a conflicted position too, because at the same time that they're supposed to ensure that everyone gets the highest quality of care possible, they're under intense pressure from corporate ownership to make sure that they provide the minimal amount of service possible so that they can increase profits and go out and bring in as many Medicare patients as possible, but also keep their staffing costs low and keep their overtime low. So it's a tough position to be in for the administrator. Perhaps the greatest advocate for the patients in a nursing home setting is a social worker, because they're supposed to be neutral. They're supposed to be on the side of the patient and the patient's family. So that's a key role for people interested in this field if they want to go into social work. Being a social worker in these kinds of settings can be a very fulfilling job. But you have to be brave, and you have to know how to speak up and not be afraid of losing your job. And it's a tough thing. But the social worker is really the one who's supposed to be the most neutral and on the side of the patient and their family. We talked a little bit about the burden of proof and how difficult it is. And so the idea, though, is that you have to balance the ability of people to continue to operate these types of facilities and give care with the needs of the patients. And so the balance that the legislature struck is by enacting the elder abuse statute, they made it very difficult at the same time. So the statute is there, but it's a high burden of proof, and it's a lot of work. So a typical day in the life of an elder abuse litigator, you have to fight and claw over everything, because in the discovery process, and I don't know how familiar you guys are with that process, but before you go to trial, you have the right to do discovery to find what evidence you have to prove your case. And when you have a high burden of proof, you need a lot of evidence. And other than the medical records, which we talked about before, which are not always, well, they are readily available, or they're supposed to be within 5 days, they have to be produced. But most of the other evidence in terms of what the staffing is like, what the policies of the facilities are, what the complaints are that are lodged against them by other residents and they're aware of, that's solely in the hands of the operators or the owners of the nursing home. You have to fight to get that, and they resist very hard. And usually you get it, but you just have to fight very hard to get it. There's a lot of review of medical records because, again, you'll find it's very seldom that you would review a medical record in these contexts and not find certain inconsistencies or false charting or people being charted on days when they're not even in the facility. But to build a case, you have to see exactly who's charting what in the records and what's the progression of this patient and their condition. How is it being tended to? Is it being tended to on time? Are changes in condition being communicated to physicians? Are the proper orders being given, and are they being carried out? So I can talk to you a little bit about where we go from here and what my thoughts are on how to improve care in these contexts, and I'm happy to take questions. First, it starts again with higher staffing, and I think one of the things that the legislature has to step in and do is to raise this minimum staffing level from 3.2 nursing hours per patient day, or they call it NHPPD, to something higher. Interestingly enough, CMS, or Center for Medicaid Services, they will, so the facility on a quarterly basis has to fill out an MDS form for each resident in the facility, explaining what all the conditions of the facility of the resident are and what their needs are, how high their needs are. And the higher the needs of the patient, the more reimbursement the facility receives for that patient. So based on the condition of the patients reported to CMS, CMS will set an expected staffing, nurse staffing level for that facility based on the overall acuity needs of the resident population. Most of the time, those staffing levels are above a 4, which is significantly higher than 3.2. And in fact, most experts agree that the minimum staffing should be raised to 4.1 from 3.2, because 3.2 is wholly deficient or insufficient for meeting the needs of all residents, even if they're not all high acuity. Next is better training. More time and effort has to be invested in the training of the staff to look for those indicators of neglect, to prevent them, to know how important it is to turn and reposition on time to avoid bed sores, to do assessments on time, so if there's a skin integrity issue, it could be caught and dealt with in a timely manner, to communicate effectively with physicians and to carry out orders, especially for patients with cognitive disabilities, to learn how to redirect the patient and use alternative methods for dealing with agitated behavior that sometimes, especially when a person with dementia is in a new environment, will display, rather than over-relying on psychotropic drugs, because that's the easier thing to do. In my opinion, I think one of the things that has to be done is that the role of related parties has to be better regulated, because there's a clear incentive for the multiple entities owned by the same companies that own the facility to skim and not give all of the care and services that they're supposed to give, because the more they spend, the less money they make. So perhaps one of the things that should happen is there should be a somewhat of a barrier to having multiple related parties being involved in the running and operation of the facility. We had and this is something, it's unfortunate, but we had, and I don't know how people in the room may feel about it, but we had a proposition on the ballot early this November. It was called Prop 46, and it was designed as, it was written as, drug testing for doctors, and at its heart, though, what I think, what we wanted to see happen was there's a limitation on pain and suffering that was set in the early 1970s at $250,000, and that's the cap on damages to this day. So, for example, if someone is severely neglected in a care setting, of course, we argue that it's called the micro cap. We argue that it doesn't apply to a nursing home setting. The nursing homes argue that it does. But even in a non-nursing home setting, even in just a medical negligence setting, when someone is severely injured, they lose a limb, or because of some injury, their life is changed forever, $250,000 is not enough money to cure what's happened to them, and it's not enough money to create a deterrence for the wrongdoers to be deterred from engaging in such conduct. So unfortunately, that proposition didn't pass, but I'm hoping that next time we get something on the ballot which just clearly says that we should raise the cap from 250 to something more reasonable, whatever that number may be. I think most compassionate-minded people would agree with that, and they would not be scared into voting against it by insurance companies who tell them their rates are going to go up. So I think that and that's the purpose of the elder abuse statute, by the way, is to create a disincentive to committing elder abuse, because it creates an incentive for attorneys to take on the cause of the elderly. But more has to be done, I think, from a legislative standpoint, to create better disincentives for this type of conduct to occur.
Do you find, generally speaking, more abuse happening in privately held companies as opposed to not-for-profits?
Generally, that's the case.
Really? Okay.
Generally, that's the case, but you'd be surprised. We have cases against not-for-profit companies where you see some of the same conduct happen. Mm-hmm. Because, at the end of the day, the incentive is always to give less and take more, unfortunately. Give less staffing, spend less on training, and take in more of the bottom line. So yes, the answer is it's less, but we still see it happening.
Sure.
But generally it's happening when there's these large chains treating their facilities almost like a fast food restaurant, where everything is done sort of just McDonald's style. Do it for as little as possible, exert as much pressure from the top as possible to provide the least amount of staffing, and to bring in as many high acuity patients as you can. So what do you think the result's going to be? Go ahead.
I was just curious, are the number of cases on the rise given the increment in the number of retired people entering the population?
I think that instances of abuse are rising, definitely, at least from what we can tell. Statistically, they've been rising as well. But naturally, when you have this sort of baby boomer generation, more people need the same level of care. And a lot of people enter the field not understanding what tremendous responsibility they have when they're entrusted with the care and custody of these types of patients. So, unfortunately, yes, it is, but there's always hope that through education and through advocacy and through effective representation, that this incentive could be created for these types of instances of neglect from the company.
To follow up on that question, do you think there should be a stronger regulation in terms of, the number of inspections that should go on in these facilities?
Well, I'm glad you brought that up. That's a key issue because, first of all, and I can speak of this from experience, and I've been doing this almost exclusively now for the last 7 years. A lot of times, people, or especially their loved ones, don't even know that what's happening to their loved one or to themselves is actionable neglect or elder abuse. So most people don't contact the ombudsman to file a complaint. Most people don't contact the Department of Public Health to come and investigate. Most people do not communicate with an attorney and see if they have a case. But I'm glad you brought that up because, unfortunately, the Department of Public Health doesn't have the resources to effectively investigate all complaints and to effectively act as a deterrent. So the investigation system is done in 2 ways. One is there's an annual survey. And so once every 14 months, surveyors come in to do an audit of the whole facility. And it's a snapshot in time. So they look at, they'll take a random sampling of patients and they look into their medical records and they see what's wrong with those patients, and it's reflective of what's happening across the board in the facility. What are the systemic problems in the facility? The problem with that is, and because I'm being videotaped, I'll only say this aspect of it, they can tell when the surveyors are coming, because if you hadn't had a survey in 14 months, you know you're going to get it when it's 14 months. So that's one problem. The second thing is that they will, and I know what I'm about to tell you may be hard to believe, but they will in fact basically shape up right before the surveyors are coming. So one of the things we've seen, we do class actions also against facilities for understaffing. And one of the things we've seen in email communications between ownership and the administrator is like the owner's telling the administrator, okay, we're due for a survey, increase your staffing, and when the surveyor leaves, it's time to rock. I mean, these are the exact words that they use.
So who normally contacts you regarding a case, since you say that a lot of the relatives aren't aware? Is it the concerned auditors, or do you have an administrator that may be concerned about what's going on and they may contact you, or how do you get your case?
It is usually the family members, but my point is it's a very small percentage of the family members whose loved ones are in fact being neglected that actually go out and file a complaint or contact an attorney. And that's what I meant by one of the ways to help prevent this is to have better advocacy and have better education on what actually constitutes elder abuse. So when someone has a loved one in a facility and they feel their instincts telling them something is off, it probably is, and they should do something about it.
Isn't part of the regulation that the facility should inform, let's say, a resident upon being admitted into a facility that you have an ombudsman to complain to if something you're unhappy with the services?
Right. It's actually listed on the facility walls in the entrance. Yes, they do have to
be verbally advised to the
Well,
residents?
a lot of times something can happen well into the admission of the patient. So whatever was verbally said to a family member who's going through the most stressful and difficult time of their life and entrusting their loved one to a facility is not something you're going to remember. That's I'm happy you brought that up, because one of the other issues that happens is they'll slip in an arbitration agreement right at the time of admission, and the person signing it doesn't understand what they're signing. Because the arbitration agreement basically takes away the right to a jury trial and says instead of going to court to litigate your case, you have to go to a retired judge who is not as compassionate as a juror, and I only say that because I'm being videotaped, who is not as compassionate as a juror may be, and is not as outraged as some of these injuries, like, you know, a stage 4 bed sore, as a jury would be, because they've seen it more. So they're going to give less damages. And the retired judge can cost anywhere between $450 an hour to $1,000 an hour, depending on who you pay. And so you have to pay for half those costs, whereas in court, you're only responsible for the lawyer's fees, who's the lawyer's taking the case on contingency, and in our office we front the cost as well. But, you know, on top of those costs, when you have a case that lands in arbitration, you have to also pay the arbitrator's fee. So every time you bring a motion that will only cost you, let's say, $60 from a cost perspective in court, but maybe 30, 40 hours of attorney time to get something as simple as a policy and procedure manual, because they're just being jerks and they don't want to give it to you because they want to waste your resources. When you do that in arbitration, you spend a few $1,000s on the arbitrator's time reading your motion and saying, yes, you're entitled to this. And so that's one of the things that's happening, is it creates a disincentive for the facility to actually provide better care, because they know it's an even more limited slap on the wrist when they end up in arbitration. So, yes.
Oh, I was just hoping you could comment on the status of criminal prosecutions for elder abuse in LA, what your thoughts are on that. Have you worked on done civil cases on any past criminal cases? And also, in terms of the CMS recommendations, are the facilities held to that? Or do you use that in your prosecution of the case? Do you say you should have, you know, gone up to this 4.1, or are you not allowed to mention that in court?
Well, let me answer your last question first. So, absolutely, you know, we prosecute the case from the perspective that the CMS expected staffing is the criteria that the facility had to meet, because part of the reason is that's the same criteria that the facility communicated to the world and to Medicare on what their actual staffing needs are. Because they told Medicare that we have this many high acuity residents, they have all these needs, give us more money. So CMS says, okay, we're going to give you this money, but you have to provide this level of staffing to care for these people. And so it's almost a misrepresentation for them. Either they're lying to get more reimbursement, that's a misrepresentation, or if they're telling the truth, which most likely is the case because they do take in a lot of higher acuity patients, especially patients with cognitive disabilities are always higher acuity, and they're not providing that level of staffing, then absolutely they're violating the statute that says they have to provide adequate staffing to meet the needs of all residents. Because this legislation that says, you know, the minimum is 3.2, it just talks about the minimum. And it's really, I mean, they over-rely on it, but it's meaningless, because there's another statute that says you have to provide adequate staffing to meet the needs of all residents. As to your first question, I actually noticed a lot of district attorney offices becoming more involved in prosecuting these kind of cases from a criminal aspect. We don't do that, and a lot of times it's not done concurrently, because sometimes, you know, the civil case will have to wait for the criminal case to be prosecuted. But that's something that I'm happy to see, that a lot of deputy district attorneys especially are becoming more active in forcefully prosecuting these kinds of cases. Because a lot of cases of, I wouldn't say every case of elder abuse we prosecute, but a lot of them, I would agree that it constitutes criminal conduct as well for some of the things that we see. Does that answer your question?
Mm-hmm.
I was wondering about the $250,000 cap. If that measure had passed and it went, I don't know what they were proposing, but I mean, would you see more prosecutions? Would firms like yours be more willing to take on marginal cases, or what did you mean by that increasing the?
I meant that, first of all, my firm, if I take on marginal cases, I'm doing a disfavor to my clients who have stronger cases, because there's only so much resources you have to litigate cases. I think it would have created an incentive or more people to take on more cases, but a lot of times people don't understand. I mean, you know, a lot of firms don't have the resources to litigate a case where you have to prove your case with clear and convincing evidence, and so they don't invest the time in understanding. You know, they'll get a case and they'll say, oh, it's medical malpractice, but it's hard to prove. We don't know how to do it. Or, you know, it's too difficult. They may not understand it's an elder abuse case. But to address where I was coming from, it's more of a humanity perspective of, you know, $250,000 is unconscionable to tell someone with the kinds of injuries I see. I mean, I'll give you an example. I had a physician friend who told me, you know, tough something, your thing didn't pass. And I told him, thank you for your sympathies. I'll pass it on to my clients with stage 4 bed sores. I mean, I don't know if you guys have any idea how painful a stage 4 bed sore is and how humiliating it is, especially when, you know, someone has to have a wound vac and has to have their stool diverted and all these things. So to tell someone who's the victim of absolute neglect, because that kind of injury doesn't happen by negligence alone. Mm-hmm. It doesn't happen because a doctor made an error and we don't want to ruin his life. It's more about intentional conduct, intentional understaffing, intentional undertraining of staff that over the course of time leads to that kind of deplorable injury. So for a person like that to be told, here's $250,000, which also has to cover their costs and attorney's fees, it is inhumane, and that's what I'm saying.
Nothing,
yeah.
Really. And why is the burden of proof so much higher? You were saying that you have to have, I forget exactly how it's worked, the...
Clear and convincing evidence.
Yeah. Why the discrepancy?
Let me go back to the policy or the idea behind it. So in an ordinary negligence case, a person has to prove by, you know, more likely than not standard, that they were the victim of negligence and it led to their injuries. The law as it is in California says that when a person is the victim of the negligence and they pass away, their negligence claim for pain and suffering, or their entitlement to pain and suffering, expires. In other words, someone could be in a nursing home and through certain negligence, they suffer an injury. It may not necessarily be neglect, which is different from negligence. They suffer an injury, and they pass away. They can, if their loved one tries to come back and litigate their claim after their death, they cannot recover for this victim's pain and suffering because it was simply negligence. So the elder abuse statute says that if someone is the victim of neglect, which is different than negligence, because negligence is the insufficient giving of care. You don't give enough care. Elder abuse is the reckless withholding of care. And recklessness is what we call a higher mens rea, a higher state of mind, because you understand the consequence of your conduct, but you still engage in it. It's like a conscious disregard for the rights and safety of others.
So it's intentional then?
It's intentional. It's intentional. Because you may not be intentionally, you don't intend to harm, but you intend to do things that you know lead to harm. So it's intentional, absolutely. In that scenario, the legislature says if you can prove with clear and convincing evidence that this person was the victim of reckless neglect, then you can recover for their pre-death pain and suffering. So in cases like this, when the patient is deceased, for the claim of the patient, the facility or nursing home will come in and defend the case and say, we dropped the ball. We were negligent. You know, we didn't do everything we had to do. We're sorry. But we didn't commit reckless neglect. Because they know that if the jury only finds on negligence, then they can no longer recover for the pre-death pain and suffering of the person that was on. So the legislature creates the incentive for attorneys to take on the cause of the elderly by saying if you can prove reckless neglect, you get to recover, and that it was ratified by a managing agent, meaning a higher up in the company, someone like an administrator or the director of nursing that runs the show knew what's happening and allowed it to happen, or turned a blind eye to it, or continue to employ someone who they knew was unfit to care for certain patients. That's ratification, or that's an example of ratification. If you can prove that, you can recover for their pre-death pain and suffering, and you can recover attorney's fees. If you prove the commission of that neglect was done with malice, which is much harder, then you can get punitive damages. But I think, to address your question now, why did they make it a higher burden of proof? I think it's because when they were enacting the statute, they got a lot of pressure from the industry, and they always continue to get pressure from the industry. You know, crying wolf, just like, you know, we saw in the ads against Prop 64 saying you're going to put us out of business, and, you know, we can't make any money, and insurance rates are going to go up, and all these things. And so the balance that the legislature struck, I think, is that they allowed the statute to be enacted, but they made it harder to prove.
Okay.
I'm just curious if the regulators work with law firms to get an idea of how they can improve on the regulations in nursing home facilities.
If you know any regulators that
I'm
want to
just
work with
curious
us,
if-
I'd be happy to work with them.
I'm just
but-
curious if they would even bother to get some data, because that's one way of looking at how
yeah.
to improve it.
So a lot of times when we have a suit going, there's a concurrent investigation by the Department of Public Health, but we've given up on them doing it timely. And nevertheless, you know, we still push, and things that we discover, because, you know, obviously we're more motivated and we're putting more time into it, so, you know, we'll take certain depositions, we'll get certain admissions from people. We kind of spend more time putting all the different pieces of the puzzle together, and we pass that information to them while they're doing their investigation. Do they review it? I don't know. I'm not there in the office, but we certainly try to provide them with that information.
Are you entitled to have access to the ombudsman reports from other residents?
No.
So you have
Short
no
answer.
idea if-
I just tried that, and the answer was no. I mean, it's you would think that you are, but unfortunately you're not. There's appellate opinion that says, you know, you're not. But hopefully that will change it, because I think it's important for people to have access to that information. Because again, a complaint investigation means that X, Y, and Z happened wrong. It was communicated to management. They knew about it. When they allow the same thing to happen again and again, that's another form of ratification or intentional conduct, because you knew what's happening, you promised to correct it, and then you allow it to happen again. In my opinion, that's malicious. So,
That is like being exemplified by the stage 4 vessel situation, right?
Right.
Because it takes a lot to get to that stage.
that's correct.
So obviously, they've neglected their responsibilities
Right.
till then.
And then they promised to the state in a plan of correction that we're going to fix this,
Mhm.
but then they let it happen again.
So is there no formal like report to where, like, from the ombudsman's reports, to where, like, let's say I'm gonna go take my parents to this nursing home, there's no way to find out any records of any other reports from
No,
ombudsman on?
it's unfortunately it's very hard. It's not easy. Any other questions? Okay, so thank you for your time. I hope that it's been effective and educational, and I hope that as you go through your careers in this field, you'll continue to be advocates for the elderly and to educate the public as much as you can about what the needs of the elderly population are, and how we can all work together to improve the quality of care. Thank you.
Thanks very much.
Thank you.
Actually, got one more question. So how did you get into this field? Why did you choose?
Yeah, everybody always asks me that. So I'm actually a big believer in justice, and I hate corruption. And I started out as a litigator, and we still do some environmental litigation, and I started doing that, and I started doing some consumer law. And I also got into a little bit of business litigation, disputes between people. And I realized how difficult the life of an attorney is, especially when you want to be great at it and you want to deliver results. And if I'm putting the time in, and I'm putting the effort in, and I'm aging, I'd rather do it at something that I find more meaningful. Not to say that anything other attorneys do is not, but I just find it very rewarding to do this kind of work. So it's a good sort of match between always being having your fighting hat on and constantly fighting, but you're doing it for a higher purpose. You're giving a voice to people who can't speak for themselves.
Mm-hmm.
So
Not just money.
not just money.
Yeah. No,
And believe me,
that's worthwhile.
there's a lot of fields of law where you have a lower burden of proof, and you don't have this argument over whether a cap applies or not, and you don't have to fork out $40,000, $50,000, $60,000 on multiple experts to prove your case, where you could put in less time and make a whole lot more money. So it's not about the money.
Sure.
And my wife will tell you not. It's not.
Good for you.
Thank you. Any other questions? Okay. Thank you, everybody.
Thanks a lot, Ben.
So we got you. Thank you.
Oh, wow. Thank you very much.
Yes.
My kids.
Thank you very much.
Now, this one I'll use myself. Thank you very much.
Thank you.
Thank you. So if you guys, you have my email.
Yes.
So if anybody has any follow-up questions, anything like that, please feel free to contact Natalie, and she has my email.
Thanks again.
Nice to meet you.
All right.
What was your name again?
Tim Stanton.
Tim Stanton.